Lordship's
from
consideration.
the prism of alcohol
The
industry.
first thing, my Lord, which is never
This
pointed
would
out,
be, my Lord, a
either
wider
in
question
Tikaramji
affecting
or
every
in
schedule
any
industry which is
subsequent
included in the
judgment
schedule
which follows
appended to this
Tikaramji.
act. Now,
None of the
my Lord,
judgments,
some
my Lord,
of
your
the
Lordship
things, my
had
Lord,
the
which
assistance
are never
of
pointed out
these facts,
to your Lordships
these
right from
position in the
Tikaramji.
Constitution.
And that is why, my Lord,
And
I
that
would
is-
ultimately say Tikaramji is wrong. My Lord, I am placing for your Lordship's consideration. The first thing, my Lord, which is never pointed out either in Tikaramji or in any subsequent
Just
judgment
giving an example.
which follows
Now,
Tikaramji.
Tikaramji says that industry has a
None of the
restricted
judgments,
meaning,
my Lord, your
meaning
Lordships had the
it
assistance
includes
of
manufacturing activity.
these facts.
It doesn't
these
say why.
position in
There
the
is no
Constitution.
logic, there is no rationale given, there is
And
no
that is-
discussion. But in the Constituent Assembly debate, Dr. Ambedkar elaborates the term and width of the word industry. But there are 4 compartments in which
So
my
just
Lord, your
giving an
Lordship is going
example,
to be assisted.
my Lord,
to reach a
Tikaramji
correct
says
conclusion.
that
My Lord, this is not
industry
a
has a
center state
restricted
issue.
meaning,
So, my Lord, this is not,
it
my Lord, an
includes
adversarial
manufacturing
position.
activities.
I am taking a
It
position
doesn't
to
say why.
assist your Lordship.
There is no logic, there is
Because
no rationale
UP is
given, there
here,
is
my
no
Lord, Maharashtra is here,
discussion.
there is nothing
But in the
political or,
Constituent
Lord,
Assembly
any federal
debate,
dispute, etc.
Dr. Ambedkar
There are
elaborates
4 stages your Lordships will examine qua interpreting each entry. First is, my Lord, called devolution rules. My Lord, in 1919, Government of India Act was passed, which bifurcated the subjects between the federal government, which is the central government in the present parlance, and the provinces, that is the state government in the present parlance. That is called devolution rules.
Yes.
Thereafter comes Government of India Act 1935, where again this bifurcation of legislative competence between federal government and the provinces took place. Third is the draft constitution, my Lord, prepared by the drafting committee chaired by Dr. Ambedkar. How they used certain expressions qua each provision and qua each entry. Now, that draft entry or a draft constitutional provision was debated, and how it takes form of what the constitution is at present. Lord, I have attempted to, my Lord, show on every my Lord, provision which is coming for your Lordship's consideration, all the 4. And if your Lordships, my Lord, would, subject to your Lordship's, my Lord, approval, I can say, my Lord, if your Lordship finds that if this would have been pointed out right from Tikaramji, or at least at some stage, Tikaramji would have been differently decided. My Lord, please come to, my Lord, page 5, page 6, my Lord. But I am skipping what is not, what I have already orally pointed out, my Lord. Lord, I come to entry 52 first. The Lordships have, my Lord, PDF page 6. My Lord Justice.
Yeah.
My Lord, para 6, I'll read with your Lordship's permission. Some of the industries have always been considered to be necessary to remain under the central control if it is found to be in national interest. But throughout, there is a chain of 3 considerations: industry, the functioning of which has a national interest; B, the industry, the functioning of which needs decision making at the pan-India level; and 3, the industry, the functioning of which needs the regulation in such a fashion that the product is equitably distributed. My Lord, your Lordships are aware, my Lord, as we pointed out in mines matters also. My Lord, some of the states are endowed with some of the most important resources. Rest of the states do not have the benefit.
Lord, some
And
of the states
the
are endowed
Constitution
with some
feels
of the
that
most
it is to be
important
left to the
resources.
Parliament that
Rest
a
of the
particular
states do not have
industry
the
should
benefit.
be
Lord, some
centrally
of the
governed,
states
not
are endowed
provincially
with some
governed,
of the
because
most
provincial government
important
will take
resources.
provincial point.
Rest of the states do not have the benefit. Lord, some
Centrally
of the
governed,
states
not
are endowed with some of the most
those
important
industries have
resources.
provincial point.
Rest of the states do not have the benefit. Lord, some of the states are endowed with some of the most important resources.
Provincial point.
Rest of the states do not have the benefit. Lord, some of the states are endowed with some of the most important resources.
Provincial point.
Rest of the states do not have the benefit.
Solicitor, all our young juniors, stand day after day. I've been noticing, with their laptops and in their hand. In the afternoon, the court master will just see if we can accommodate them behind you immediately so they can sit for the day.
Yes, Manoj, that's what Manoj, I was saying.
I just told the court master to find out.
Manoj, who are not appearing, for example, Manoj, I request,
Outside, also we'll see if we can even put some stools or something like that.
No, Manoj,
They can just
some of the councils, Manoj, are not appearing in the matter. They can, Manoj, perhaps accommodate those who are appearing.
But we'll try and put some additional chairs also for the juniors so that they have they can
So-
so they have
so
to be
kind
close
of
to they have to be close to whoever is arguing.
Yes. So kind of your lordship. But I am immensely grateful. But entry 20, Manoj, this is the route. 1990 Government of India Act. Development of industries in cases where such development by a central authority is declared by order of the Governor General in Council expedient in public interest. Well, development is underlined by me. It is my emphasis. Now come to Malad, what happened in 1935. It remains the same. Development of industries where the development under federal control, the word used is now federal control, is declared by federal law to be expedient in the public interest. Malad, federal law is Malad, earlier version of parliamentary law. Now, Malad, how the drafting committee drafts this entry. Development of industries where development under the control of India is declared by Parliament, by law, to be expedient in public interest. It retains Manoj, substantial heart and soul, but makes minor changes. Now, please see, Manoj, how it stands today. And there is a reason. The reason is explained in the Constituent Assembly debates. The word development is replaced by the word control.
And there is, interestingly, if you see our constitution, though, of course, we now know it's a federal constitution. That's how we have interpreted. Constitution doesn't use the word federal anywhere at all.
Yes.
Unlike what happened across the border, if you look at the Pakistani, they have used the word federal government, federal. We don't use the word. We have used central, union, but we have not. We have eschewed the word federal in the constitution.
I think, Manoj, this is my
semantics more than anything else, but at least in the birth of the constitution, they didn't use the word federal.
It's my perception, Manoj, subject to your lordship's approval. Manoj, the federalism has several facets. Your lordships, I'm not going on general principles of it is quasi-federal and leaning towards unitary, etc. I'm not on that. When it comes to the subjects which need distribution of national resources, but we have, for example, 25 federating units, hypothetical example, 25 states. The classical definition of federalism means each unit is independent in its own way. It's not sovereign the way American states are sovereign, but they are independent in their own way. Any interference by the center may perhaps not breach the element of federalism which is involved in the constitution without naming the term federalism. But now, kindly see this nuance which is my perception. Lord, when the center, having an authority under the Constitution, does something to ensure that 3 or 4 states having incidentally major resources of a particular character do not deprive rest of the provinces, namely federating units, of their right of equal treatment, and the center interferes and makes equitable distribution, that is also an element of federalism. So there, to maintain federalism, the power is conferred upon the center. That now you step in. The only condition is the center must have a backing of a constitutional provision to do so. And entry 52 is one such provision. And it is, in my respectful submission, in furtherance of the principle of federalism. Now, please see page 7. Industries declared by Parliament by law to be necessary for the purpose of defense or for prosecution of war. But I have put it here because entry 24 list 2 mentions entry 7, therefore not for immediate reference.
Yes.
And 52, the way Malot ultimately found its place in the Constitution as it stands today, industries, the control of which by the Union is declared by Parliament by law to be expedient in the public interest. Lord, the earlier 1919, 35 and the draft used the expression development. Now it is replaced by the word control. And there is a debate. Why are you doing this? Some of the members felt that why are you curtailing the power of the Parliament? And the answer given by Dr. Ambedkar would show that Tikaramji is wrongly decided because this is not pointed out. Tikaramji, in so far as it says that industry is restricted to only manufacturing, is contrary to what the constitutional framers envisaged. Page 7. Let me read this debate, in extenso, because this would have a serious bearing on what ultimately your lordship decides. Honorable Dr. B.R. Ambedkar, sir, I move that for entry 64, 64 is present 52.
Yes.
For entry 64 of list 1, the following entry be substituted. Whenever there is a change in the draft constitution and what is moved, the word used is substituted. Industries, the control of which by the union is declared by Parliament by law to be expedient in the public interest. Then Kaka Bhagwant Roy says this, that he moves an amendment in this, that in amendment number 35 of list 1, in the proposed entry 64, that is present 52, the word industries, the word development of industries be substituted. It appears from the amendment which the Honorable Doctor, this is the parliamentary debate. It's not my noting, my note or something.
The Constituent Assembly debate.
The Constituent Assembly debate. I only highlighted. Highlighting is not supplied. It appears
like from call the Dr. Ambedkar, the Honorable Doctor.
Yeah, yes.
Deference to Dr. Ambedkar.
To the person, my lord, and the persona. It appears from the amendment which the Honorable Doctor has introduced in the original entry that he wants to hand over all powers regarding industries to the center. It is very good. Center ought to be strong, and during transition, such powers are essential for the industrial development of the country. But in normal times, the center should not be vested with such authority. India is a very big country. She has many provinces. These provinces have their own difficulties and can understand their problem much better than the center. The problem of industries is very complicated. Therefore, so far this question is concerned, every province should be given facilities to solve its own problems. If you make the provinces responsible for industrial development and do not give them powers to deal with the situation, then the problem of provinces cannot be solved and it will retard the industrial progress of the country. Although I am somewhat deviating from the point, yet I must say that the present industrial policy of the center will prove a stumbling block in the path of the country's progress. Kindly pause here for a minute. Historically, the first industrial policy came in 1948 when the debates were ongoing. And Lord Kaka Bhagwant Roy was a prominent leader who was opposing that industrial policy per se. Therefore, he says that I am deviating, but I don't agree with the industrial policy. Nothing turns on debates, though. Mr. President, you are only speaking on your amendment, but you are opposing it. Kaka Bhagwan Roy, I bow down to your ruling, but I would like to say that so far industries are concerned, the provinces should be entrusted with necessary powers, for they can understand the problem of their industries better. With these words, I would request the Honorable Doctor to accept the amendment. Then, my Lord, Sri H.V. Kamath comes. I move the amendment as under, that in the amendment 35 of list 1, 6th week, in the proposed entry 64, my Lord, present 52, for the words the control, the words the development and control be substituted.
Yes.
Then he further, my Lord, sir. Then, my Lord, Mr. Kamath further makes his point before the Constituent Assembly. This amendment includes or embraces the amendment just now moved by Honorable Friend Kaka Bhagwant Roy. The original entry as it stood in draft constitution referred to the development of industries. I wonder why the drafting committee has suddenly developed an antipathy to the word development in this entry. My Lord, Mr. Kamath seems to have the very good sense of sarcasm, my Lord, which will come, my Lord, further. My amendment is on the lines of a legislative measure which was introduced in the Assembly during the last budget session and which has been referred to a select committee. The bill provided for governmental action in industries, the development and control of which was to be regulated by the center, and the title of the bill was Industries Development and Control Bill. That is to say, the subject matter of this entry has been already taken cognizance by the central government in a bill, the title of which includes not merely control, but the development of industries which are deemed necessary or expedient in public interest. Now he is, my Lord, sarcastic. I realize it is quite possible the drafting committee, owing to the excessive strain under which it had labored during last 2 years and especially during the last few weeks or months, is liable to commit slips here and there. But I hope that the drafting committee has not developed a closed or calcified mind which is not receptive to any change whatsoever. But the sarcasm also, my Lord, was with a reasonable degree of respect and restraint.
Yes.
I think that the meaning of this entry will be more adequately and more fully covered by amending this word control on the lines I have suggested and seeking to incorporate in this entry not merely control but also the development of industries, which means industries, the development and control of which by the union is declared by parliament by law to be expedient in public interest. I move amendment so and so. Now, my Lord, Dr. Ambedkar answers this. And this is missed. This is the heart and soul of entry 52, which is not assisted with either in Tikaramji or any subsequent judgments which follow Tikaramji, so far as the width of the term industry is concerned.
Yes.
Honorable Dr. B.R. Ambedkar, sir, the entry as it stands is perfectly all right and carries out the intention that the drafting committee has in mind. My submission is that once the center obtained jurisdiction over any particular industry as provided for in this entry, that industry becomes subject to jurisdiction of Parliament in all its aspects. Kindly mark this, Malord. In all its aspects, not merely development, but it may be in other aspects. Consequently, we have thought that the best thing is to put the industries first so as to give undoubted jurisdiction to Parliament to deal with it in a manner it likes, not necessarily development. Once the industry comes in the first schedule of IDRA, all its aspects are within the control of the central government. And Tikaramji says, no, only manufacturing part. How, why, what rationale, no reasoning, no assistance, and this is completely absent.
At least the view that was given by Dr. Ambedkar, as it appears, was that when the control over industry is given to union, it will cover all aspects and will not be restricted to what is given in Tikaram, that is manufacture. Now, what are the all other aspects? Can we just articulate straight away?
In my respectful submission, this is not from the debates. But when Dr. Ambedkar says that once it comes within the control, all aspects would come in the control, would be right from sourcing the raw material till the distribution of the product. And I'll tell you, Lordship, why. Why, this is my respectful submission. Lord, which are these industries which are intended by the framers of the Constitution to be put under 52? The entries, my lord, as the judgments and the subsequent development goes, where the central government or the center needs equitable distribution and at fair prices. My lord, I'll take your lordships to the...
That is the objective.
No, introduction and the SOR of IDR also, my lord, throws a direct light. And therefore, for example, my lord, taking this example just to answer your lordship's query. But in a given set, I'm sorry, my lord, the chief.
Yes.
But even given set of facts, lord, maybe 10 lines, 10 years down the line, or maybe 15 years before, there is a scarcity of sugar, which happened, lord, during Second World War. The sugar was imported into Britain, and because of the Second World War, all imports were stopped when Churchill took over. Suppose some situation arises. The raw material for production of sugar is sugar cane. If all industries which are dealing with sugar or using sugar cane as a raw material start using sugar cane only for the purpose of, say, making alcohol and not sugar, the central government can step in. Suppose considering the situation at a national level, the sugar cane growers say that we will not sell the sugar to sugar factories. We will sell only to alcohol factories because we are getting more price. And the interest of the nation is that right now we need production of sugar more because we are deficit in sugar. That's the intention. If that is the intention, then how, my lord, I'm posing a question to myself, we exclude the raw material from the control. Center can do nothing, my lord, in the example which I have given. That country needs sugar, there is a sugar scarcity, sugar production needs to be enhanced, which even Tikaramji says manufacturing is within my control. But the raw material growers, the sugar cane growers say, no, we will sell it to only that factory which makes either potable or non-potable alcohol, because I am getting more price. The central government can come out with a regulation that no, this is the way in which you will distribute your raw material. You distribute your product, which is a raw material for the industry.
Some specific parts of an industry, even after a declaration is made under entry 52 of list 1, is taken out of the scope of entry 52 of list 1 by entry 33 of list 3. So distribution, because entry 33 of list 3 is not a matter of interpretation. It's a constitutional prescription that even after an industry is declared under entry 52 of list 1 as an industry, the control over which is deemed necessary by Parliament in public interest, the central government in public interest. Despite that, entry 33 says trade and commerce and production, supply and distribution of the products of any industry, whether control of such industry by the union is declared by Parliament by law to be expedient in the public interest. So clause A of entry 33 clearly has a reference to entry 52 of list 1, though it does not specifically refer to entry 52.
Doubtless.
Right? Therefore, at least that part, even if it is declared under entry 52 of list 1, that part which falls under entry 33 of list 3
Will be
is
extracted.
taken, is extracted away from entry 52 of list 1.
No,
And then given to the states as well as the center.
it is added to the term industry as understood in Tikaram. That not just manufacture. You can include product, its distribution, etc. But my lord, I just gave an, my lord,
In fact, entry on a slightly different plane, entry 33 seems to indicate that entry 52 would not otherwise be confined only to manufacture. Because if entry 52 was confined only to manufacture, there was no need to create entry 33. Entry 33 was to carve out something out of entry 52, which would have otherwise been within the fold of entry 52. That's really
expanding the 52, my lord.
But what it does is, in recognition that entry 52 will cover trade, commerce, production, supply, and distribution, it takes it out of entry 52 and puts it in entry 53.
This is, my lord, since I was answering my lord's question, my lord, my proposition, which I will develop a little later, if I am right and I have understood, my lord, Dr. Ambedkar's understanding correctly, then even in absence of entry 33, my lord, can the Parliament not only under entry 52
Of course,
control everything?
that was Dr. Ambedkar's understanding, but they were not dealing in that part with entry 33 of list.
There is an interesting debate on entry 33 as well. But, my lord, I am putting it in two alternative ways, my lord, for your lordship's consideration. A, please consider entry 52 the way, my lord, in my submission, Dr. Ambedkar understood that everything concerning the industry. Then, my lord, I don't have to fall back on entry 33, list 3 also. Parliament can exclusively under 52 enact a law which takes into consideration right from raw material till end product and its distribution. But alternatively, 33, my lord, as your lord, my lord, the Chief Justice has rightly said, my lord, would come in the aid. And why entry 33 came, my lord, I'll assist your lordship.
In fact, part of the IDRA may be traceable to entry 52. Part of the IDRA may be traceable to entry 33 also.
It's a ragbag legislation, that's our argument.
Parliament is also competent under entry 33 to control production, trade and commerce, production, supply and distribution.
Lord, why are we, all of us on this side, my lord, are enamored by the raw material part? Because Tikaramji happened to have that fact situation. Otherwise, there is no doubt that if you control an industry, you control every part of industry, start from finish. But Tikaramji, as a matter of fact, Tikaramji, which is consistently used for a proposition, which it did not decide. I'll come to that, my lord. Tikaramji, my lord, kindly, just I'm flagging it for your lordship so that it can be kept in mind as per my submission. Tikaramji, the ratio in Tikaramji is merely this. There is an IRDA and there was a state act. Sugar was when Tikaramji was decided a scheduled industry and therefore IRDA applied. The state law concerned sugar cane, and the question was, is there any repugnancy between the central law which governs sugar and the state law which governs sugar cane? The court examined both the acts and says there is no repugnancy. It should have stopped at that. Anything other than that, I'll show, my lord, because unfortunately 1 or 2 paras were cited in Tikaramji, my lord, before your lordships and subsequently also. Everybody has cited 1 or 2 paras without showing, my lord, the background, factual narration and what exactly is the ratio in Tikaramji. Tikaramji merely says that there is no repugnancy between IDRA and the sugarcane control order of the state government. That's the only ratio. Now, my lord, I'll proceed further, my lord. Page 9, after Dr. Ambedkar's, my lord, reply, my lord, this is accepted, my lord. I need not read
Yes.
it further. Please come, my lord. Page 10.
This argument is accepted. 33.
Kindly come to, my lord, para 10 now. Page 10, para 8. Lord, I have said Tikaramji doesn't take note of this. Lord, I have a separate argument, separate section how Tikaramji is not a good law, A, and how Tikaramji's few of the findings are only obiter because it was never called upon to decide that. But that's a separate issue. I'm not, Lord, touching that right now.
production used in entry 33. The word production is used because there are lots of industries which are not covered in any of the lists. For instance, textile industry, leather industry, so on and so forth. So, supposing it is not taken over by the, not taken over by.
I agree. Therefore, concurrently,
IDR.
state also
IDR.
can, subject to 33A. If there is a 52 law, state cannot. Otherwise, but state can. Therefore,
What happens is,
concurrent.
if supposing the industries are not the ones which are specified in list, perhaps entry 52 list 1, then the production may also go there. There are certain industries specified in list 3 itself. There are certain industries like electricity and other things specified in list 3. Now, where would the production go then? Obviously, it can't go to list 2, it can't go to list 1, it has to go to list 3.
Correct, Malod.
So that's the reason, Lord, why production is used there. That's all I wanted to clarify, Lord.
Anyway,
Rest
you
we'll
can
explain, we'll
please
explain
don't,
Dr. Ambedkar's observation.
Yeah, I would request Mr. Dwivedi not to.
Therefore, yeah, we quite understand that once an industry is declared as a controlled industry, we use that expression under entry 52, ordinarily everything would be covered by that aspect.
There is one more example I can give. The Lordships
Because whether Parliament regulates it or legislates upon it under entry 52 or entry 33 is really, it was one significance. That if Parliament is regulating on those 5 subjects, trade, commerce, production, supply, distribution, then it is regulating only under entry 33. The consequence is, 1, the parliamentary law is supreme. 2, the states can also enact a law.
subject to 254.
Yes, subject to 254. So states can enact the law unless Parliament intended to exclude all power of the states to enact the law under entry 33. Parliament can always do that.
But if there is a law under 52, entry 52, then 33A would denuate the state legislature from its power on trade, etc.
That extent.
Yes, to that extent.
No,
Not to that extent.
No.
It's up to that extent.
That extent.
For trade, etc. Correct.
And there's one addition to your written submission which I'll make, just one phrase, just 1 second. I was just thinking I'll tell you that at this point. Then there's no problem. Then it's absolutely we are all on one. In your para 8 where you say,
Yes. The restrictive meaning.
Just read that, solicitor, again.
Well, may I read?
Yes.
The restrictive meaning to entry 52 list 1 given in Tikaramji and followed subsequently in subsequent judgments relying upon Tikaramji in absence of being assisted with the crucial constituent assembly debates is thus not a good law. The Parliament under list 1 entry 52 is fully entitled to control everything as per its wisdom. The requirement of particular industry, it's its wisdom, the requirement of particular industry, and to achieve the stated object of IDRA when Parliament is satisfied that. So this is SOR and the industrial policy.
There I would only make one little addition.
Please.
The Parliament under list 1 entry 52 and list 3 entry 33. The only thing is that the latter is also subject to state concurrent powers. Subject to Article 254.
Well, that doesn't affect my argument, but hypothetically as an academic question.
Well, once we say that section 18G of the IDRA is traceable, because 18G seeks to impose measures on controlling trade and commerce. But not production. Not production. Trade and commerce. Trade and commerce.
I would, my lord, request for, we never did this.
If a section 18G covers trade and commerce, supply, distribution, all right, then to that extent, section 18G requires a notified order. And in the absence,
Lord, yes, that's a separate argument. There is a separate argument. My lord. I have an argument on absence of notified order under 18G, plus 18G is not the only provision which occupies the field under entry 52 read with 33.
And if 18G does not cover production,
there are other provisions. There are other, the entire act is not read before your
We'll
lord.
read the act, Mr. Solicitor.
Yes, my lord.
All right.
18G is not the
At
only
this
provision.
stage, actually, we'll move forward. At this stage, we wanted to only flag that true, entry 52 on a declaration is comprehensive, the control is comprehensive. But however comprehensive the control on a declaration under entry 52, it will still be subject to entry 53, entry 33. Because entry 33 extracts out of 52 certain aspects, 5 facets, and places it in the concurrent.
Just academically, my lord. Just, my lord, to
Because
assist your
clause
lordship.
A of entry 33 is a direct reference to entry 52.
Let us, my lord, leave it at that. My lord, I have
Just look
another.
at it. Just look at it. Just look at it. Entry 33 says 33A, so that we have absolute conceptual clarity on this.
Yes.
Now, see, interestingly,
Yes.
entry 52 is not made subject to entry 33,
Yes.
right? Because entry 52 has not been made subject to entry 53. But if you now see entry 33, are there any entries in list 1 which are made subject to list 3, by the way?
No, my lord, not to our knowledge, but we'll
Not, I don't think there's anything like that. Entry 32, right? That property of the union subject to legislation. But there's no entry specifically in list 1 which makes it subject to list 3, right?
My learned friend wants me to see property, the union and revenue
Ah.
therefrom, but as regards the property situated in a state, subject to legislation by state, save insofar as parliament by law otherwise provides. So again, parliamentary supremacy.
Now, see, if you look at now entry 50, let's see 52 first.
Yes, ma'am. 52. Industries, the control of which by the union is declared by parliament by law to be expedient in public interest. My lord, kindly examine a scenario.
Now, Mr. Solicitor, just conceptually, now let us look at 33 for a moment.
You must say not in public interest.
The word,
It's mentioned in the first schedule. And first schedule is only with regard to manufacture or production. But when it comes to 18G, production is not there. There it is control of supply, distribution and price. There is a distinction.
My lord, please bear in mind, 18G is the only section relied upon by them.
you're looking at other sections.
I am going to look at other sections, show other sections also.
Fair enough. But one thing which I wanted to point out to you is this, that entry 33A, the expression, the control of such industry by the union is declared by parliament by law to be expedient in the public interest. These words are bodily the same as entry 52 of list 1. Identical words in entry 52 of list 1, identical words in entry 33 of list 1. These words are identical to those, right?
It's referable to 52.
Right. Therefore, what does 33 say now? Let's read 33.
Trade and commerce in and the production, supply and distribution of the products of any industry where the control of, so scheduled industries, let me.
So,
Scheduled
what this
industry.
means is, the moment there's a declaration by parliament under entry 52 of list 1, entry 33 of list 3 kicks in regard to trade and commerce, production, supply and distribution. So entry 33A in that sense is a carve out of entry 52 of list 1.
Look, may I put it slightly differently academically? This suits my eye.
Then we can't say that notwithstanding entry 33A, all these aspects, namely trade and commerce, production, supply and distribution, will still be under the exclusive domain of parliament under entry 52. They will still be under the domain of parliament, but not an exclusive domain.
May I just, my lord, point out, just, my lord, examine this. This doesn't, my lord, change my submission or.
That is what.
Let's suppose the constitutional framers have chosen to give concurrent jurisdiction on some aspects of a controlled industry under section 33. Lord, kindly visualize a situation academically to test, my lord, the interpretation. Suppose there would not have been any entry 33. only entry 52.
It would all go under entry 52, undoubtedly.
Then in that case, Lord, right from sourcing the raw material till distribution,
Absolutely. There is
the power.
probably you may be right.
Here, my lord, 33 is given with a view to see that under some circumstances, in absence of a law under 52, the state is also competent how to distribute, how to, etc., whatever, how to deal with the product. So therefore, an additional concurrent power is given to the state. I may necessarily not depend upon 33. In absence of 33 also, the power would flow, I mean
Under
parliament,
entry 52.
52.
But when Parliament is enacting a law on the subjects under entry 33, we can't then say that that law is relatable only to entry 52. Then it is within Parliament's legislative competence. Nobody can doubt that the IDRA is within Parliament.
I'm not,
But that part of the law then falls under entry 33. And then we have to see to what extent does that law exclude the power of the states, one, and to what extent that law leaves open some fields for the state. Because that, what is left open to the states is, after we look at Parliament's legislation, Parliament can legislate on everything under entry 33. We have to then construe that law, IDRA,
I bow.
the area which is left open to the states.
I bow.
If at all some area is left open to the states.
Please see page 10, my lord. These are the 4 contingency that I have formulated. When, my lord, a 52 law
discussion on entry 33A by Dr. Ambedkar.
It's coming up. It's coming, my lord. Therefore, I have, my lord, my colleagues and my lord, we have worked it on that, my lord, on everything.
That will be very relevant.
Absolutely, my lord. But if your lordship permits, my lord, I may go chronologically, my lord. I have
Sure, no
so that the flow is maintained. That's all.
Absolutely, you can.
So, my lord, when 52 kicks in, my lord, 33 we for the time being, my lord, post it as on the side, my lord, for the time being. The activities of an industry or industries which affects the country as a whole. This is the first condition. Then second, it ought to be governed by economic factors of an all India import and cannot be permitted to be decided by state according to their provincial interests. Planning of future development and sound and balanced national perspective is required to be kept in mind, and to achieve inter alia the object of equitable distribution on pan-India basis at fair prices, the control of all aspects of a particular industry must be taken over. Parliament makes such statutory declaration in the Act. We hear, my lord, section 2. Now, my lord, please see para 10. My lord, this is IRDA, the introduction as given in the Act and the statement of objection reasons. Am I with your lordships at page 11?
Yeah, that.
On 6th April
Am I with your lordships at page
1948,
11?
the central government
On
announced
6th April
its industrial
1948,
policy, which was
the central
approved by the
government
central
announced
legislature.
its
This is what
industrial
was,
policy, which was approved by the
commented
central
upon by one of the
legislature.
honorable
This is
members
what
of
was
the assembly, that this is not a correct
commented
policy,
upon by
etc.
one of the honorable members
As
of
per the policy,
assembly, that this is not a
The
correct policy,
development and
etc.
regulation of a
As
number
per
of
the
important
policy,
industries,
the development and
activities of which
regulation of a
affected
number
the
of
country as
important
a whole,
industries,
and
the
the development
activities
of
of
which
which
ought to be
affected the
governed
country
by
as a whole,
economic factors
and the
of all
development
India
of which ought
import
to be governed
were
by
required
economic
to be
factors
brought
of all
under the
India
central
import
control. This is what,
were
my lord, the
required to
Parliament
be
says.
brought under the central
To
control.
achieve this
This is what,
objective,
my lord,
the
the
IDRA bill
Parliament
was
says.
introduced in the state
To
legislature.
achieve this
Then,
objective,
my
the
lord, SOR.
IDRA bill was
The object
introduced
of
in the
this
state
bill
legislature.
is to provide
Then,
the
my lord,
central
SOR.
government with the means of
object of this
implementing their
bill is
industrial
to
policy,
provide the
which
central
was
government
announced
with
in
the
the
means of
resolution number so and
implementing
so
their
dated
industrial
6th
policy,
April
which
48,
was announced in
and
the resolution
approved by
number
the
so and
central
so dated
legislature.
6th
The
April
bill brings
48,
under central
and
control and
approved by the
development
central
and regulation
legislature.
of a
The bill
number
brings
of
under
important
central control
industries,
and development
the
and regulation
activities
of
of
a
which affect the
number of
country as a
important
whole.
industries,
The entire
the
activity,
activities
not
of which affect
manufacturing
the
effects.
country as a whole. The
Country
entire
as a whole,
activity,
and the
not
development of
manufacturing
which
effects.
must be governed by
Country as a
economic
whole, and
factors
the
of
development
all
of
India
which
import.
must
Manoj,
be
the
governed by
development would
economic
necessarily
factors
involve
of all
right
India
from
import.
sourcing
Manoj, the
raw materials
development would
till
necessarily
distribution. It
involve
has to be done
right
at an all
from
India
sourcing
level
raw
with a
materials
national
till
perspective in
distribution.
mind.
It has to be done at an all India
The
level
planning
with a
of future
national
development
perspective
on
in mind.
sound and balanced lines is sought to be
The
secured by
planning
the
of future
licensing of
development
all
on
new
sound and balanced
undertakings
lines is
by the
sought to be
central
secured
government.
by the
The bill
licensing of
confers
all
on the
new
government power
undertakings
to make
by the
rules
central
for the
government.
registration
The
of
bill
existing
confers on the
undertakings,
government power to make
for
rules
regulating the
for the
production
registration of
and
existing
development
undertakings,
of the industries. Please
for
mark the word
regulating the
production.
production and development of the
in
industries. Please mark the
and
word
for
production.
consultation with
Development
provincial
of the
government
industries in
on
the
these
schedule
matters.
and for
Provision has
consultation
also
with
been made for
provincial government
constitution of a
on
central
these
advisory
matters.
council.
Provision has
prior
also been made
consultation
for
with which will be
constitution of a
obligatory
central
before
advisory
the central
council,
government
prior
takes
consultation
certain
with which
measures
will be
such as
obligatory before
revocation of
the central
license
government
or
takes
taking over
certain
the
measures
control
such
and
as the
management of
revocation of
any
license
industrial concern.
or taking
Now,
over
my
the
lord,
control
Constituent
and
Assembly
management
debates.
of any industrial
Lord, this is
concern.
the debate
Now, my lord,
dated 5th
Constituent Assembly
January
debates.
1949.
Lord, this is the debate dated
Shyama
5th
Prasad
January
Mukherjee.
1949.
Sir, when clause 2 was inserted
Shyama
as
Prasad
drafted,
Mukherjee.
the
Sir,
idea of the
when
government
clause
was that
2
in
was
respect of
inserted
the
as
entire
drafted,
concurrent list,
the idea
it
of the
should be
government
open
was
to
that
the
in
Dominion
respect of the
legislation.
entire concurrent
Dominion
list,
would be,
it should be
the
open
parliament.
to the Dominion legislation.
Corresponding
Dominion would be, you mean
legislature
the
to pass
parliament.
laws for
The
the purpose of exercising
corresponding
executive
legislature
function.
to pass
At
laws
present,
for the purpose
so far
of
as the concurrent
exercising
list is
executive
concerned,
function.
the Dominion
At present,
legislature may
so far
pass
as the
laws which
concurrent
will
list is
supersede
concerned,
any
the
laws
Dominion
passed by the
legislature may
provinces.
pass
But so
laws
far
which
as
will
executive
supersede
authority
any
goes,
laws passed
it
by the
can be
provinces.
discharged only
But
by
so
the
far as
provincial
executive
government.
authority
In the
goes,
new
it can be
constitution under
discharged
Article
only by
60,
the
which
provincial
has
government.
already been
In the
adopted,
new
it has been laid down
constitution,
that
under
even
Article
with regard
60,
to the
which has
concurrent
already
list,
been
it will
adopted,
be
it has
open
been
to the
laid down that
Dominion
even with
Parliament to
regard
pass
to the
laws
concurrent
for
list,
the
it
purpose
will
of
be open to
exercising
the Dominion
executive
Parliament to
function.
pass laws
I'm pausing
for
here
the
for a
purpose
minute.
of
The law made
exercising
by the Parliament,
executive function.
implementation at the
I'm
state
pausing here for a
government.
minute. The law made by the Parliament, implementation
Dr.
at the
Mukherjee
state
says
government level.
that he was also Dr. Shyama Prasad.
Dr. Mukherjee
That
says
now for
that he was
executive
also
function you
Dr.
have carved
Shyama
out this,
Prasad Mukherjee.
you removed this
That
exception.
now for executive function
The
you have
question
carved out
arose
this,
whether
you
any
removed
such
this
power
exception.
should be taken over by the
The
Dominion
question arose
Parliament during the
whether
interim
any
period.
such power
At
should be
present,
taken
during the
over by the
Government of India
Dominion
Act, the
Parliament
Dominion
during the
Parliament
interim
and
period.
the Dominion
At
government
present,
can
during the
exercise
Government of
authority
India
in
Act, the
respect of
Dominion
matters
Parliament
which
and the
normally fall
Dominion
in the
government can
concurrent list
exercise
in three
authority
ways.
in respect of
We have the
matters
essential
which
supplies
normally fall in
commodities
the
act,
concurrent
which
list in
relates
three
to
ways.
certain specific
We have the
commodities
Essential Supplies
such as
Commodities Act,
foodstuffs
which
and
relates
certain
to
other
certain
commodities
specific
in respect
commodities
of which
such
the
as
Dominion
foodstuffs
Parliament and the
and certain
Dominion
other
government have
commodities in
complete
respect of which
legislative
the
and
Dominion
executive powers.
Parliament and the
The
Dominion
power will
government have
lapse in
complete
1951.
legislative and
Please mark
executive
this.
powers. The
Secondly, we
power
have
will
a
lapse in
provision which lays
1951.
down
So please
that
mark
development
this.
of industries
Secondly, we
which,
have a
in the
provision which
opinion of
lays
the
down
Dominion
that
Parliament is of
development of
all India
industries which,
importance,
in the
can be
opinion
taken
of the
up by
Dominion
the
Parliament,
Dominion
is
Parliament.
of all India
But
importance,
that relates
can be
only
taken
to
up
the
by the
development of an
Dominion
industry,
Parliament.
which may
But
be
that
so
relates
described by
only
the
to the
Dominion
development of an
Parliament.
industry which may be so described by the Dominion Parliament.
Yes.
I'm sorry.
Actually, Dr. Shyam Prasad
Yes,
Mukherjee has made a
I'm
very
sorry.
important point that
Actually,
control
Dr.
covers
Shyam Prasad
aspects
Mukherjee has made a
beyond
very
development.
important point that
That's the respectful submission,
control
which
covers
was
aspects
initially, my lord, in a
beyond
different
development.
language
That's the
accepted by
respectful
Dr.
submission,
Radha,
which
that
was
we are
initially, my lord, in a
expanding the meaning of
different
development
language
by
accepted
using
by
the
Dr.
term
Radha,
control.
that we are expanding the meaning of
I'm grateful,
development
my lord.
by using the term control. I'm grateful, my lord.
Only one date, your lordships may note, which I forgot.
Only one date, your lordships may note, which I forgot. I think it was August 14.
doesn't come.
My lord, the date may be noted, my lord, in the earlier submissions. My lord, when I read Dr. Ambedkar's clarification is 31st of August 1949. The date may have some relevance because on that very day, the discussion about 33 also took place. Therefore,
What is the date?
31st August 1949.
31, August.
31st August 1949. So now I'll come back, my lord, to
In fact, my
page.
sister, Justice Nagaratna, said something very valuable, which is that she said that my learned sister said that control will include development and regulation.
Correct.
Both.
I'm grateful. My lord, I'm grateful. It's a wider term encompassing both. Lord, I was on page 12, my lord. We have
Yes.
Essential Supplies Commodities Act, which relates to certain specific commodities such as foodstuffs and certain other commodities in respect of which the Dominion Parliament and the Dominion Government have complete legislative and executive powers. This power will lapse in 1951. Secondly, we have a provision which lays down that development of industries which, in the opinion of the Dominion Parliament, is of all India importance, can be taken up by the Dominion Parliament. But that relates only to the development of an industry which may be so described by the Dominion Parliament. It has been felt that in respect of industrial development, it is not sufficient that Dominion Parliament or the Dominion government should have power only for the purpose of developing industries which are deemed to be of an all India importance. Development has been interpreted to exclude regulation and control. But what your ladyship says, which is negative, he is putting it negatively, that it excludes. Development has been interpreted to exclude regulation and control of such industries and also trade and commerce in such industries, control of production and distribution of products of such industries. For that purpose, it was first thought expedient that wide powers might be taken by the Dominion Parliament even during the interim period by a suitable amendment of the Government of India Act. Apart from industrial development, there were certain other matters like statistics, censoring of films, and also industrial disputes in respect of which it was thought desirable that the central government should take adequate powers. So far as industrial and labor disputes are concerned, as has been explained by Sardar Patel, this is a provincial subject, but it has been felt desirable that there should be some uniformity of legislation followed by necessary executive action with regard to industrial tribunals which may be constituted under provincial laws for the purpose of settling disputes. After consultation with provincial government and some of the provincial premiers and representatives of provincial governments who were present in Delhi, it has been deemed desirable that during the interim period, completely wide powers need not be taken over by the Government of India, but a suitable amendment may be made only in respect of those particular items which are now of an urgent character and which require an immediate solution. For this purpose, you will find from amendment number 9 that we have referred to industrial and labor disputes, trade and commerce in and production, supply and distribution of products of industries and development of which is declared by Dominion law to be expedient in public interest. The sanctioning of cinematograph films for exhibition and inquiries and statistics for the purpose of any of the matters in the concurrent legislative list. This will mean a consequential change in clause 7 as originally provided in the bill. The later portion of clause A will be omitted and put in the concurrent list. Now please see, the result will be that so far as legislative powers are concerned, the Dominion Parliament will have ample powers to pass laws wherever necessary, and such laws will supersede provincial laws, if any. So far as the executive authority is concerned in respect of these matters, it will also be open to the Dominion Parliament to pass laws and take over responsibility for executive administration. In case such a step is considered to be desirable or necessary, sir, it is not intended that provincial government should not be utilized for the purpose of coordinating the policy of the central government, even in respect of those matters where central regulation and control are necessary in the interest of the whole country. Obviously, in normal circumstances, the executive machinery which will be utilized will be the provincial governments themselves. But if an occasion arises when it is necessary for the central government to exercise executive authority in respect of matters which are considered to be of an all India importance, power to do so have to be taken over by the Government of India and Dominion Parliament. A question has arisen whether this power should be exercised by the Dominion legislature without consultation with the provincial government. Hitherto, whenever the central government or the Dominion legislature had an occasion to take steps for introducing legislation for development of industries, previous consultation with the provincial government, that was a conventional method, not a statutory mechanism. I believe on a suitable occasion, when the matter comes up a little while later, Sardar Patel will give an assurance on behalf of the government that during the interim period before the new constitution comes into force, if it is necessary for the central government to move in accordance with the powers which are now proposed to be taken under amendment